You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, thank you very much for tuning in to the next episode of the Max Planck Lawcast. As always, it's great to have you here with us today. On today's episode, we're going to be talking about the law of restitution for unjust enrichment. But we're going to be putting a little twist on things and talking about the history of the legal concept in India, and particularly its domestication to the Indian legal system via British colonisation in the 19th century. Moreover, we'll ascertain how ensuing developments in India have contributed to modern-day debates about the scope of the law, not only in India itself, but also in the UK. To do so, I'm joined in the studio by Ragini Surana. Ragini is from India and is currently a doctoral student at the Max Planck Institute for Legal History and Legal Theory in Frankfurt. The concept of restitution for unjust enrichment. In my mind, it seems fairly straightforward. Chris is unjustly enriched by a contract from Ragini. Ragini is then able to obtain restitution for the money, goods or services. I'm guessing, though, that I'm missing something here.
In a way, you're right. The law does look at relationships between two people. But the question of whether something is unjust has a very specific answer. So unjust in the unjust enrichment law is more a term of art. The law of restitution for unjust enrichment has more to do with the rules established by case law, but not with abstract ideas of justice.
Okay, right. So just to see something is unjust per se is not so straightforward.
I think for most of us it is,
but not
for the law of restitution it's not. It has very specific answers.
Okay, right. Well then, let's talk maybe to break it down then maybe about before looking at how it was applied in India, let's look maybe at the history of the concept of unjust enrichment and restitution itself. I gather just from what you've said as well that something that borders on a number of areas of law. You've probably got tort law, you've got contract law, equity, but maybe it doesn't quite fit neatly within any of them. Is that correct?
Yeah, in some ways it is arguable that in the common law, the law of unjust enrichment has a relatively short history. But the only reason for that is because it's sort of drawn on these other areas of law, and it's the rules that are now classified as unjust enrichment, which were earlier classified as tort or contract or equity.
Okay, so it's been right. So there's kind of these law. The concept of unjust enrichment existed in one way, shape, or form, but now, when has it now been defined as its own concept?
Yeah, exactly.
Yeah.
I mean, the rules remain the same regardless. Okay. It's just how we categorize them and what we make, what concepts we make out of them.
And when did one begin defining the concept of unjust enrichment in its own
So
sense?
The first textbook on the law of unjust enrichment, which was called the law of restitution, came out in 1966.
Oh.
But the first attempt at theorizing a concept of unjust enrichment was as late as 1991.
Oh, okay. Oh, so it's quite very modern then.
Yeah, I mean, I think lawyers aren't known for that.
Hold on, I just thought we're at the Legal Institute for Legal History, but this is a modern concept.
I think that is a talk on contemporary legal history that I can get behind.
Okay, sure. Okay, the concept of mistake. I mean, I read a little bit up on this before, obviously. It obviously is, at least historically, it would seem, at the heart of unjust enrichment. Is that correct? Or where does it, or can you define what this concept is?
Yeah, I can see that you've done your research for this podcast.
I've tried to do my homework,
yeah. You're absolutely right. Mistake is usually placed at the heart of a lot of common law models of unjust enrichment. And I think an important reason why is because of how intuitive it is to reach out to, because how many of us have not made a mistaken payment or overpaid someone that we owed a lesser amount to?
Right, okay, sure. Mm-hmm. Okay, and that in its sense, or at the core, would be an unjust enrichment then?
Yeah.
Okay. If it's intentional or unintentional, or both?
I think the concept of mistake is also where it gets complicated,
Okay.
because then the question becomes, what kind of mistakes do we give restitution for? And again, there are people who argue that for the longest time it was only liability mistakes that we
Right.
gave restitution for. So a liability mistake is making a mistake about whether you owe someone something or not, whereas there can be other causal mistakes, the other wider category of mistakes, which kind of lead you to make the payment but have nothing to do with whether you think you owe them or not.
Ah, I see. Okay.
So if you pay the wrong person, that's not a liability mistake.
No, true, but it could still be considered a mistake, and that where unjust enrichment, yes, a third party then would have been unjustly enriched who didn't even know about it.
Yeah, but we're not getting into
No,
that.
let's not do that. That sounds complicated.
I should, but not on this show, maybe.
Certainly. Well, I will have you back for another episode where we talk about that. Okay, so I guess we've got now a little understanding then of what unjust enrichment is. We've got the concept of mistake at its heart. It's obviously a concept that's been within the law for centuries, but has been more recently defined as such in the 1990s, correct?
Yes, exactly.
Okay, good. Because now I want to make that segue and then look then at the historical background to the concept of restitution for unjust enrichment in India, which is, I guess, primarily what we're talking about and what your PhD is on as well. To do so, though, I'd ask if you could give us maybe a rundown of colonial India in a way. That would be interesting for myself and the audience. And then before we look at how the laws themselves actually then moved to India.
Yeah, I mean, I think the East India Company starts out in the year 1600 with monopoly rights for trading with India. And that's sort of how they establish their stronghold in areas like Madras and Bengal, where they set up factories. So it's very much a commercial undertaking in the beginning. And the lawmaking power sort of comes from their ability to make it's sort of like a company having bylaws, but when your factory occupies an entire town, the bylaws have some significance.
Sure.
As the years progress, the sort of power the company exercises also changes, and it starts to sort of interact with what we would today call sovereignty. And I think that comes a lot with the military power that the East India Company exercises in Bengal and places like, So it's after 1757 when they win the Battle of Plassey, do they get the official title from the sort of central rulers in India at that point, who were the Mughals. Mm-hmm. And they are then appointed the Diwans, which is a sort of executive and judicial title. And that's where it's really on this English company to make laws or administer justice in a country that doesn't belong. I mean, that they're not native to.
Okay. When we say it's up to the company to administer the laws, it's up to then the CEO and the administrative functionaries then to decide on how they want to administer the law in the cities, basically, that they are trading hubs.
There's also very different ways the company acquires power in different parts of India, and the exact nature of jurisdiction it exercises depends. So, for example, the city of Bombay, which was actually came into English hands as dowry, was then given to the East India Company, and then the kind of sovereignty they exercised over it was very different from what they had in Bengal, where they held power through the Indian emperor at the time.
I see. Okay. Oh, wow. So the East India Company has very different areas set up throughout India, and they are governed in different ways depending on how they got there. The local inhabitants, what they think of the East India Company being there, whether there's a military presence required. Yeah.
I mean, I think in this way they were very reluctant rulers. So for very long they insisted that the law that they exercised was only on their employees. Okay. Or people who worked for them. But in a factory town, I think that extends to a lot of people.
Sure, because I guess they had if they're the East India Company, they're obviously a trading company primarily. Is that correct? Manufacturing and trading. And so they obviously need contract law.
Yes.
Yeah. That's right, amongst themselves and the local parties who they're dealing with.
Yeah, and this is where they had this interesting approach. So Warren Hastings, who was Governor General at the time, he wanted to sort of rule India with their own law. So he sets up these courts which then aim at applying each individual's personal laws. So between two Hindu parties, the idea was Hindu law would apply, and between two English parties, English law would apply.
I see. Okay. Right. Okay. And did this work? And what happened when you had an English party and a Hindu party?
Yeah, in these, in those cases, it was general principles of justice, equity, and good conscience that they had to fall back on. And in most cases, for contract law, it meant English law. I think that it worked out. So there are people who argue that courts administered by the company were preferred by litigants who were at a disadvantage in the indigenous legal system, but the attempts of the East India Company to administer Hindu or Muslim law have themselves been subject to a lot of criticism in the way that they understood law in a very Western construct, whereas law existed in a very different way in India at that point.
Sure.
Yeah.
Okay. The East India Company no longer exists, so something obviously happened along the way here. So what then happened there with the East India Company?
I think this is where we go back to your earlier question about the CEO. And sure, the company had a board of directors, but it also had a lot of parliamentary oversight just because of the idea of the corporation has developed.
I'm guessing some of the parliamentarians may have also been investors in the East India Company as well, right?
I mean, there were also those who were detractors of the monopoly it exercised in India. And there were also several accusations of misadministration of justice. Warren Hastings, who we mentioned earlier, was impeached. There were a lot of corruption charges that were levied against the employees of the company. I think it was more employees of the company coming back with a lot of wealth from the colony that was then seen by existing upper classes as a threat.
Okay. All right. I see. Did the Parliament in Westminster, did they have much to say then about how the East India Company behaved in India at the time, or did they let them pretty much do what they wanted to do?
I think the trial of Warren Hastings is sort of what comes to my mind when you ask that question. So, Edmund Burke famously led that charge, and the trial is sort of seen as this microcosm of the debates that exist around whether to keep India as a colony and what status India has as a colony within the British Empire.
Okay.
Yeah.
Okay, so there was discussion at the time anyway about whether, what do we do here? How do we move on? Do we continue with this status quo of just having the East India Company, or are we going to get more active in, and whether we want to make it a official colony?
Yes.
Okay.
There is also one thing I should mention, which is the year 1857, which is, I think for Indian historians, especially significant as one of the first wars of independence, but by others it is dismissed as a mutiny among soldiers or a series of revolts and peasant rebellions that happened at an inconvenient time for the East India Company. It's after the events of 1857 that the East India Company is dissolved and the British Crown takes over.
Oh, okay. Dissolved then by Westminster. They decide to dissolve it, and then it becomes a crown colony in India. Just the cities where the East India Company was, or India as we know it today?
No, just the cities where the East India Company was. But I think at this point it had significant territory in the northern parts of India.
Don't go away, because we're going to have plenty more for you after this short break.
Welcome to Max Planck Law, one of the world's largest networks for legal research, based in Germany. Our world-class institutes invite applications for fully funded PhD and postdoc opportunities in almost any area of law. Join a thriving community of over 400 researchers in an international and interdisciplinary environment. Experience the high quality of life that Germany offers while collaborating with colleagues across institutes, working and writing in English. We provide you with unique specialist libraries, excellent workspaces, and support in developing your research and your academic career. Apply today. For more information, visit law.mpg.de.
Welcome back to the Lawcast. Thanks for listening to us today. The East India Company is dissolved, and we then get the British Crown taking over. It becomes a crown colony. What do they then find on the ground when they go there and say, right, we're going to administer this colony? They obviously see that based upon what you said, the East India Company's been doing things in a maybe somewhat haphazard fashion, using different styles of laws, maybe a different court here, different laws are applied here, depending on the parties. I'm guessing that they wanted to try and streamline things.
Yeah, that sounds about right. One of the proclamations made by the Crown to the people of India is an easier to use law. And that's pretty much part of the law reform movement that then is set into motion. The Law Commission for India is set up, and they look into codifying a substantive law for India in areas such as contract.
Okay. And previously, at this time in England, I guess codification wasn't that common, is it? Or
so arguably there were calls for codification in England as well, and it's after they received no answer in England that India is seen as a place where it can be achieved. Because
no answer in England, that there's no one who says, we should definitely codify now, whereas they now think, all right, if there's no backing for codification here at the moment, we can try it in India, in these new colonies.
I mean, several years passed through.
Sure.
Yeah,
right.
Yes.
Okay. Yeah. But that was the concept is then that we need to find a law that can be easier to apply, that applies to all parties, and the way to go about that is to codify the law. That then, was an experiment of codification, and somehow along the way, the concept of unjust enrichment also was codified, or at least entered the legal system in India.
Yes. So what's interesting to me is the Indian Contract Act specifically. And I focus on that because in the last years of the law of unjust enrichment, it's believed to have existed as a sort of implied contract. So it's really the textbooks on contract law, which were a novelty in the 19th century, that you find the rules related to unjust enrichment.
There was more said maybe than had previously been so in one place about unjust enrichment.
Yes.
Okay, so they brought a concept together. And this was the India Contract Act, which talked about the concept of unjust enrichment?
In keeping with the understanding of unjust enrichment at the time, it's more the specific rules that one finds in the Act.
Okay. An implied concept then of unjust enrichment then, with the various rules of mistake, for instance.
I think a good in-between term is quasi-contract, because I think it indicates that it's not contract while also keeping it in the contract. I mean, justifying keeping it in the Contract Act.
Okay. When was the Act?
1872.
Right. Okay. And so that's when the Indian contract law, the Indian Contract Act was passed in 1872. What would kind of interest me is, I'm guessing then there was a Contract Act also passed in England and Wales at some point later on. Is that correct?
No.
No. Not at all.
Certain parts of contract law, like the sales of goods or bills of exchange, were codified in England, but the general principles of contract law are not.
Oh,
and
not.
I guess
my question I wanted to ask was whether Indian the contract law and also the concept of unjust enrichment developed then in lockstep with what happened in England and Wales, or whether they kind of parted ways over the ensuing centuries.
So I think both. With some rules, you really see that they develop in lockstep. So in cases where a contract is voided because it was obtained through undue influence or coercion, the rules remain the same, and they remain the same in both jurisdictions. But in other cases, like payments of taxes that are later declared to be void because the authority didn't exercise the right jurisdiction, didn't exercise the right power.
Oh, yeah.
It seems that recovery was allowed in India much earlier than it was in England.
Oh, okay. I was hoping that they wouldn't be allowed to recover at all. Oh, who was allowed to recover?
The taxpayer.
That's okay then. All right. Okay.
I mean, it's a good thing.
That's a good thing. I thought it was the other way around. Okay. So certain branches developed different speeds then.
Yeah, and in different ways.
Okay. Yeah, right. I see. Do they kind of all get to the same end point or a solution to a problem, or was it more than one way to skin a cat in a way, or was it, or would they also sometimes arrive at different solutions?
Oh, I mean, I actually really like that question because I think it gets at the idea of the common law itself. And I mean, in one way, India and England share the process, which is this idea of judicial precedent and how law is made through accumulation of decisions. They did have different starting points for some of the rules.
Are you able to provide examples of how legal and doctrinal developments in India, and particularly also with the Indian Contract Act, had an effect on the eventual codification of at least certain parts of contract law in the UK?
I mean, I think it definitely gathered support for the idea of codification, especially for discrete areas of the law, like the law of sale of goods. But in terms of the law of unjust enrichment, I can't think of any influence that goes the other way, sort of.
Well, Ragini, it sounds like you've got to still do a little bit of research for us there, so I'm going to have you back on the show, I'm afraid, to find out more about this.
I would love that.
Okay, well, thank you so much. I wish you all the very best for your PhD work, and then, we look forward to having you back on. You're welcome. Take care.
Bye.
Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.